Trustees of Barry Congregation, Jehovah's Witnesses against BXB.
Mr. Counsel.
My Lord, might I deal with a couple of preliminary points before returning to the topic of risk, if I may? And the first of those is the question that your Lordships raised about who is the employer, the identity of the defendant. Can I just set out what our position on that is? We would submit that although by the time this case has reached this court, the congregation of Barry, the Barry congregation, is the appellant. Throughout the proceedings, the congregation, the Barry congregation, was named as a nominal defendant, but the court, both at first instance and in the Court of Appeal, analysed the case on the basis that it was looking at the Jehovah's Witness organisation as a whole. And the reason for that lies in the correspondence which there was between the parties at a very early stage. And, my Lord, we've got a couple of letters. We tried to hand them up, and we were told that, unfortunately, they should have been sent electronically, which, of course, we will do. But I wonder whether we could pass copies of the letters
yes, we can look at them.
to you. Thank you very much. The correspondence goes back to late 2016. Your Lordships, when you have them, should have a letter, first of all, from a firm called Anderson Olivarius Law, which was the firm who represented the claimant, the respondent, and then the response from the legal department of Watchtower.
Thank you.
And your Lordships will see that the first letter, the 25th of November 2016, from AO Advocates, as they're called, which, as I say, was the firm representing the respondent until the fee earner moved firms, was seeking to identify a nominal defendant. In part, that was because in other litigation, the legal department for the Watchtower had sought to take various points about the defendant's identification. You'll see in the section entitled Nominal Defendant that in the second paragraph that they say, in an attempt to move matters forward, narrow the issues between the parties and avoid unnecessary delays, we invite you to provide a nominal defendant within 14 days. In the event that you don't, then proceedings will be issued against all of the individual trustees of the Barry congregation. And it was certainly our understanding at that time, from information provided to us by the legal department of Watchtower, that the trustees were effectively the elders of the local congregation. So in the case of Barry congregation, trustees were the elders. That was our understanding, although I think it's now suggested that by this stage it had become an unincorporated association. But in any event, that letter prompted this response from Watchtower. In paragraph 1, we confirm that Watchtower Bible and Tract Society of Pennsylvania is the correct defendant, and they, of course, later became first defendant. WT Pennsylvania was the legal corporation used by Jehovah's Witnesses to communicate the appointment of Mark Sewell as a ministerial servant and then elder, as well as other ministerial servants and elders of Barry congregation at the time. And then at 3, in your letter, you ask whether we can provide the name and address of a nominal defendant against whom proceedings may be issued. We reiterate that WT Pennsylvania is the correct corporate defendant. We've been authorized to accept service of documents and correspond on behalf of WT Pennsylvania. And out of caution, no nominal defendant having been identified, both defendants, WT Pennsylvania and the Barry Congregation Trustees, were sued. Then we come on later to the trial. At that stage, of course, the claim was against both defendants. And at no stage at the trial, or even in the pleadings, was it ever suggested by the defence that one should differentiate in any way between D1 and D2, if I can call them. In other words, that the position in relation to the Barry congregation was in some way more limited or could only be put on a more narrow basis. And it was clear from the analysis of the judge at trial that he was considering the overarching Jehovah's Witness organisation as the potential, in inverted commas, employer. And as I say, at no stage has it ever been suggested that in respect to the Barry trustees, if I can call them that, a point would be taken that they cannot be held responsible because they were not the employer. And one can see that in his lordship's judgment. If you go to the core bundle, to his judgment, which begins at page 153, or effectively 154, in paragraph 1, the judge says this, after setting out the events, he says in the second sentence, the trustees of the congregation are the second defendants to this claim. The first defendant is the worldwide governing body of the Jehovah's Witnesses, which has offices in New York State.
I'm very sorry, which paragraph are you?
It's paragraph 1 on page 154.
Thank you.
138.
Thank you.
It's 138 in the bundle, non-electronic. Yeah.
I'm looking at the wrong one. I'm in the core bundle. Paragraph 1, he goes on in the last sentence, second last sentence of that paragraph. It's not necessary to consider further the relationship between the first and second defendants because the first defendant has agreed that it will satisfy any judgment against the second. In the remainder of this judgment, I therefore refer to the defendants without differentiating between them. And you'll see from the whole judgment that throughout the judge describes them as the defendants rather than carrying out any exercise in analysing them separately.
I appreciate it doesn't appear to have occurred to anybody until the case has arrived here.
Yes.
But this is all very well in relation to funding and having what we call a nominal defendant, but none of that bears on the question of who the employer is for the purposes of vicarious liability.
Well, that is so, because no point has ever been taken on this issue.
Well,
and
it's not a matter of a point being taken. It's the application of the stage 1 test requires analysis of a relationship, and the relationship is between Sewell on the one hand and whoever is said to be his employer on the other hand. And the problem in this case, so far as stage 1 is concerned, seems to be that no one has had any clear idea of who the other party to the relationship was.
Well, everybody has proceeded on the basis that the other party is the overall Jehovah's Witness organisation. Indeed, time and again in submissions.
Do you mean Watchtower, Pennsylvania, as clearly identified as the appointor of Mr. Sewell
Yes.
in their letter, or do you mean some abstraction consisting of anybody you like to put in the bucket, from Watchtower, Pennsylvania to Watchtower, London to some regional?
I'm insofar as everybody's ever given it any thought, which is not much, I accept. It's Watchtower, Pennsylvania,
Right.
because they are.
They seem to have said, look, we appointed him, so as far as we're concerned, we're the right defendant. I mean, do you adopt that? Because if so, as far as I'm concerned, that probably clears it up.
We do, and that's how everybody has proceeded on that basis. And indeed, it's never been suggested otherwise. And the only reason that there's never been an issue raised, well, two reasons. One is they've never raised an issue, and secondly, because the first defendant have agreed to indemnify the second defendant. But just as an illustration of
Well, to illustrate the importance of it, if it were the Barry congregation, for example, then the claimant would be liable to herself because she was a member of a congregation at the relevant time. So it certainly clarifies matters if it's the American corporation whose relationship with Mr. Sewell is actually an issue.
Yes, although it may or may not be liable herself, depending upon whether there are, in fact, trustees, namely the elders, because, of course, she was
we
not
haven't
an
seen
elder.
the trustees, so we don't know what the trustees function.
Well, we haven't been given that.
We could have asked for it. It would be a disclosable document.
Yeah.
And they're sued, as I understand it, simply as representatives of the congregation.
Yeah.
Anyway, it doesn't matter. I mean, if the employers had been the congregation, which is what we seemed to be talking about yesterday, then she was a member of the congregation, and therefore she would be one of Sewell's employers.
Yes. One sees it. Your Lordship doesn't have this document, but of course, I said already that the point was never taken at trial. It was never taken in the Court of Appeal either. Now, by the time of the Court of Appeal, there had been a judgment against. The judgment refers to both defendants, and the appellant in the Court of Appeal.
It's a judgment against only one of them.
The order was against one. Yes.
Which defendant is the judgment against?
I'm sorry.
Which defendant is the judgment against?
Barry.
Expressed as the trustees of, or
Expressed as the trustees of.
It's page 128 of
Yes.
the bundle.
If it helps, the reason for that was that the judge indicated, as he had already done so in the first paragraph, that because of the agreement that the first defendant would indemnify the second defendant, and therefore there had been no separate analysis of the first defendant's position, then the appropriate judgment was against D2, Barry trustees. Now, in the Court of Appeal,
The actual order for the actual judgment for damages is curiously against both defendants, I think. There's a page, it's numbered 129 in the
yes, it says both defendants.
Well, what page of the...
Well, depending on which bundle your Lordship is in.
Big one.
In the core bundle.
Page bundle.
Yes, in the core bundle it is.
I think it's 147.
No, it's 220 in the core bundle. Paragraph 217B. The second last paragraph.
I'm looking at the order.
Oh, I'm sorry.
So it's a 220.
220 is the last paragraph, the second last paragraph of the judgment, which refers to the defendants.
Thank you. Well, that's against... No, the defendants.
The defendants.
Defendants.
The judgment was against both. I thought you just told us it was against the Barry congregation only.
Well, there's confusion because the earlier order of the 30th directed that there be judgment for the claimant against the second defendant in an amount due to be assessed. And then once the assessment's done, the order is actually granted against both.
Against both. To add a little bit to the general confusion, if I can call it that, when the case gets to the Court of Appeal, of course, the only appellants are the Barry trustees. And throughout the submissions on their behalf, there's no distinction made. It's never suggested, for example, well, the appellant's position is much more limited because it cannot be responsible, for example, for the removal or appointment of elders. Indeed, quite the opposite. You don't have the document, but if I can read paragraph 74 of the appellant's skeleton argument in the Court of Appeal, says this: the fact that the Barry congregation could and did remove Mark Sewell as an elder is of no relevance either, he said. Well, of course, as we know, strictly speaking, the Barry congregation couldn't do that. But the point is that there was no distinction being made between Barry congregation or the organisation as a whole, because everybody proceeded on the basis that the organisation was responsible without...
Can you tell me what a nominal defendant is? I mean, it seems that in the correspondence between the solicitors, which we've only got a bit, I'm not commenting about that, please understand, they seem to think they know what a nominal defendant is. I'm coming lately and not really quite sure what everybody means by nominal defendant. And you're either a defendant or you're not.
Well,
unless a representation order is made, and there's no suggestion that's been done in this case.
My understanding is that a nominal defendant is someone being put forward as a defendant who will satisfy a judgment, whether or not, technically speaking, they might be said to be liable, but I may have misunderstood that.
The way the judge puts it is really as clear as mud. He doesn't distinguish between the defendants. Issue 2, I'm afraid I'm looking at the hard copy, with a paragraph just above 132 of his judgment. The heading is, Issue 2, are the defendants vicariously liable for the rape?
Throughout, he refers to the defendants.
Yeah, stage 1, at the first stage, the question is whether the relationship between the defendants and Mark Sewell is capable of giving rise to vicarious liability. And his conclusion is, in the penultimate paragraph, is 217B, the defendants are vicariously liable.
Yes, right from paragraph 5, in fact, he refers to the defendants. And in fairness to the judge, he wasn't being invited to draw any distinction between the two.
No, but he can't do his job properly in relation to stage 1 unless he is focusing on a particular relationship, and he clearly hasn't done that.
Well, in my suspicion, he was, in the sense that he was looking at the position overall, because he was referring to factors such as the ability to remove and appoint an elder, which, as we know from the evidence of Mr. Schofield, cannot have been done by the Barry trustees on their own.
The evidence before the judge was the evidence of Mr. Schofield, and as I recall it, that evidence was that the ultimate appointer was the service department of the British branch, the branch office, but it seems that Watchtower, Pennsylvania appears to be treating that as their agent.
Yes. I've seen a letter, and it can be provided to you, which you haven't got, which does seem to indicate that Watchtower, Pennsylvania is responsible for all of these organisations. I'm sure to get the wording of it.
Yeah. But insofar as there was someone taking a decision, it does seem to be the service department of the British branch.
Yes.
And the British branch appears to be a company limited by guarantee and a registered charity. I'm just looking at the small print at the bottom of their letter that you've just handed up.
Yes.
So I mean, I don't know what the corporate status of the Pennsylvania organisation is, and I don't think this letter tells us that it operates in Britain through a presumably wholly owned guarantee company.
If you look at the letter, there's some information about that in the paragraph I didn't read. Please find attached the power of attorney through which WT Pennsylvania operated in Britain. We also attach a deed of transfer, between WT Pennsylvania and WT Britain, which explains the adjustments.
I mean, it may be that the guarantee company gives a power of attorney to its American parent. Without the power of attorney, everyone's guessing what it says.
Yeah. It's interesting, the submissions as recorded by the judge reflect the same confusion. The submissions to the claimant, paragraph 153, are concerned with the Jehovah's Witnesses. Talks about the organisation from the governing body in New York downwards, without really focusing beyond, more specifically than the level of the entire organisation.
That's right.
The defendant's submissions at 155 focus specifically on the relationship between Sewell and the Barry congregation, with in brackets, or the worldwide organisation.
Yes. And that's with respect to constant theme throughout, and a theme of our submissions as well, which was that there was no distinction being made. And once we spoke of the organisation, Jehovah's Witnesses. In fact, it's something that I've done during the course of this appeal.
Yeah. Well, there it is. We can't.
It is.
But it's very different from, for example, the Christian Institute case, where the court looked very closely at the relationship between the various ecclesiastical bodies in order to get a clear picture of who was in a position akin to an employer.
Yeah. Well, there it is. Now, you'll hear, of course, from my learned friend in due course, of course, but as I understand it, he isn't going to be suggesting that we've sued the wrong defendant.
No, that's not the concept.
Can I, again, by way of preliminary matters, just very briefly deal, before I forget, with a point that my Lord Briggs asked me about yesterday. And I may have slightly overstated the case. Your Lordship will remember that you raised a query as to where in the evidence came the suggestion that publishers were encouraged only to associate, or mostly to associate. Yeah. The judge deals with it. I think I may have slightly overstated it in a way. He deals with it in his judgment at Core Bundle, page 163. Where at paragraph 3, and this is a reflection, I think, of BXB's evidence, which he accepted, Mrs. B was introduced to the social network of Jehovah's Witnesses from about March 82 by Mr. B's cousin.
So which paragraph, sorry?
Paragraph 33 on page 163 of the core bundle. I'm in the electronic bundle.
At that paragraph 33?
Yes. Mr. and Mrs. B raised their children as Jehovah's Witnesses, which she says meant mixing predominantly with other families who were also Jehovah's Witnesses. And then she goes on to deal with the position of full-time work. And so perhaps it's slightly too overstated to say that all publishers were encouraged mainly to associate with other publishers, but that's how it happened in her case. Yeah. So can I then go back to the submissions that I was making yesterday and deal head on, if I may, with the question of risk, the creation and the enhancement of risk. We had a discussion yesterday about the risk created by the assignment of a role, in this case to an elder, and the extent to which it forms part of the analysis when considering whether to impose vicarious liability on a defendant. And the issue arose as to whether it really formed part of the test at stage 1 or stage 2. I'm not going to make any further submissions on that, and because in my submission perhaps it matters not, because on any view the concept of risk we submit is an important part of the test of vicarious liability, and it's particularly important when considering whether there is a close connection between the role, which is defined at stage 1, and the tort. And necessarily that question requires an analysis as to whether there is a close connection between the risk produced by the assigned role and the tort committed. And to demonstrate, if I may, why we say that is so, both on the authorities and as a matter of policy, can I just remind you of the authorities, first of all? I took you yesterday to the observations of my Lord Reid in Cox, which appear at page 498. It's paragraph 24 of the judgment. It appears at 498, and I've taken you to that already more than once. That's cited with approval by Lady Hale in the Barclays Bank case. And of course, Lady Hale was dealing with a case which was a stage 1 case only. And it's referred to, and again, I've taken you to it, but might I just remind you in DSN, in the Blackpool Football Club case by Lord Justice Stuart Smith, at page 468 in the bundle, he says this, paragraph 102 in the middle of the page, questions of vicarious liability, and he's dealing here, in fact, with stage 1, will generally not arise unless the tortfeasor can be described as doing something for or for the benefit of the employer or their enterprise. That will therefore seldom be a determinative characteristic. More is required, both at stage 1 and stage 2, than that the employer has engaged the tortfeasor to carry out work which gave them the opportunity to commit the tortious act. To my mind, the authorities suggest that it's the combination of the creation of enterprise risk inherent in the employer's business, combined with the measure of control, if only in assigning the tortfeasor to roles that significantly enhance that risk, that will frequently provide the touchstone for the synthesis of stage 1 and 2. That necessitates a close examination of the relationship between tortfeasor and the person upon whom vicarious liability may be imposed, both when addressing whether their relationship is one which is capable of giving rise to vicarious liability and when considering whether the connection that links the relationship between D1 and D2 and the tortious act is sufficient to justify the imposition of vicarious liability on the facts of the particular case. And that's where we got to, I think. But it's also a theme, this risk is a theme which runs through all the earlier cases, and particularly in Lister itself. Can I take you back to Lister? And apologise if I've taken you to passages to which, at least in part, you've already been taken. But first of all, if I may, page 609 in that judgment, the judgment of Lord Millett, at paragraph 65, he says, vicarious liability is a species of strict liability. It's not premised on any culpable act or omission. An employer who is not personally at fault is made legally answerable for the fault of his employee. It's best understood as a loss distribution device. And he then refers to Attire's accidents compensation in the law and articles by Attire. The theoretical underpinning of the doctrine is unclear. Glanville-Williams wrote, vicarious liability is the creation of many judges who've had different ideas of its justification or social policy, or no idea at all. Some judges may have extended the rule more widely or confined it more narrowly than its true rationale would allow. Yet the rationale, if we can discover it, will remain valid so far as it extends. And then his lordship refers to an observation by Fleming that the doctrine cannot parade as a deduction from legalistic premises. He indicated that it should be frankly recognized as having its basis in a combination of policy considerations. Most important of these is the belief that a person who employs others to advance his own economic interest should, in fairness, be placed under a corresponding liability for losses incurred in the course of the enterprise. he suggested at page 171, the master ought to be liable for all those torts which can fairly be regarded as reasonably incidental risks to the type of business he carries on. These passages are not to be read as confining the doctrine to cases where the employer is carrying on business for profit. They're based on the more general idea that a person who employs another for his own ends inevitably creates a risk that the employee will commit a legal wrong. If the employer's objectives cannot be achieved without a serious risk of that wrong, the employer ought to be liable. The fact that his employment gave the employee the opportunity to commit the wrong is not enough. He's liable only if the risk is one which experience shows is inherent in the nature of the business. And then it's, if I may, paragraph 82, so on a few pages to page 614, he's referring to that particular case when he says at paragraph 82, in the present case, the warden's duties provided him with the opportunity to commit indecent assaults on the boys for his own sexual gratification, but that in itself is not enough to make the school liable. The same would be true of the groundsman or the school porter. But there was far more to it than that. The school was responsible for the care and welfare of the boys. It entrusted that responsibility to the warden. He was employed to discharge the school's responsibility to the boys. For this purpose, the school entrusted them to his care. He didn't merely take advantage of the opportunity which employment at a residential school gave him. He abused the special position in which the school had placed him to enable it to discharge its own responsibilities, with the result that the assaults were committed. And he goes on at 83, I would regard this, he refers to Paisley, which I'm going to come to, I would regard this as in accordance not only with ordinary principles deducible from the authorities, but with the underlying rationale of vicarious liability. And then he says, experience shows that in the case of boarding schools, prisons, nursing homes, old people's homes, geriatric wards and other residential homes for the young or vulnerable, there is an inherent risk that indecent assaults on the residents will be committed by those placed in authority over them, particularly if they're in close proximity to them and occupying a position of trust. The risk has to be, of course, of the tort committed, as is illustrated by his example of the groundsman or the school porter. In the case of the groundsman, it couldn't sensibly be argued that that increased the risk of sexual abuse. That's an important limitation, we would say, on the ambit of the risk-based test, because it has to be of the risk of the tort which was committed. But in other contexts, that is what the defendant is doing. Lord Millett gives examples relating to boarding schools and the like, where it's known that the risk of abuse is increased. The focus very much is on the risk, not the activity. That may be relevant, the activity may be relevant, as may the authority which the person has. But the risk is the focus in my submission in this and other cases. And one can see it again.
Sorry, the groundsman you can easily distinguish on the basis of what are the particular tasks assigned to him and whether those tasks have a close connection with the wrong that was committed. You don't have to go into risk in order to get there in relation to the groundsman at all.
That may be right, and as I say, the activity may be an important factor, but overall the factor is risk, because there may be other cases, in my submission, where one can't look sensibly at the activity. One needs to look at other factors, such as the level of authority which has been imposed. Your Lordship is, of course, quite right in relation to that example.
Another counterexample is the Barclays case. Barclays, by sending young women for medical examinations, could be said to subject them to a risk. That tells one nothing, literally nothing, about whether the medical examiner was their employee or not.
Yes. But Barclays, of course, was only dealing with the stage one rather than the close connection. So it's a slightly different position. in my submission.
And Lister is only dealing with stage 2. Obviously, we're dealing with employees.
Well, in this context, certainly is dealing with stage 2.
Yeah.
Can I take you to...
So you're accepting that risk is irrelevant to stage 1 and that may have a bearing on stage 2?
Well, as I said already, I'm not going to make any further submissions on that. But so far as that is concerned, certainly there in Barclays and indeed in Blackpool, the courts approached it on the basis that it was relevant to stage 1. But my submission is that risk is an important factor, and of course it's relevant to stage 2.
I mean, the difficulty, I think, is, if I might put it this way, people have often pondered as to the underlying policy of vicarious liability. The passages that you're here pointing to reflect what I think has become the generally accepted position that it is a form of enterprise liability and risk associated with that theory. I think we've got statements made by the President in various cases indicating that. So in a sense, it's the underlying policy, and the question is really how far that impacts on the 2 tests that we've now got. And one would think that it's primarily of underlying relevance when one's dealing with stage 2, but I think you may be saying, well, that may be generally the case, but the underlying policy might conceivably also have an influence at stage 1.
Precisely, my Lord. There are many ways in which there could be a connection that's going on to stage 2, but the underlying point is risk, is that the employer, by appointing somebody to that role, has created a risk.
But yes, but the stage 1 question is identifying the nature of the relationship and deciding whether it is akin to employment. In answering that question, one may have to look at the scope of the employment in forming a view as a whole as to what was assigned to this individual and what was the relationship between him and the person asserted to be in a position akin to employment. But I think the language of synthesis and so on muddles the issue, because there are 2 questions to be answered. What was the relationship? And at stage 1, one will consider the scope of the employment in assessing the relationship. And stage 2 is the question of the closeness of the connection between the tort and the activities or authority assigned to the quasi-employee.
Yes.
So it may not matter whether you, from your point of view, whether you put it in 1 or 2, but it might be in stage 1 or stage 2, but it might be conceptually a lot neater to keep the question in stage 2.
Yeah. Well, I'm not going to make any further submissions on that, because my point is that it's really important. As your Lordship rightly says, activity could be one way in which stage 2 is made out. There are others, and the fundamental point is, has there been a creation of risk? Because after all, the employer has the ability, and this is one of the policy factors in the Lord Phillips 5 policy factors. The employer has the ability to insure against that risk, and that's an important policy factor.
Can I just ask you about paragraph 83 in Lord Millett's judgment, page 614? Experience shows that in the case of, etc.
Yeah.
So he's drawing on knowledge at that stage of abuse of the young and vulnerable.
Yeah.
Now, is there any equivalent that you can point us to that experience shows that there is rape, etc., in relation to the Jehovah's Witnesses organisations?
Well, I think the point made in the judgment and picked up in the Court of Appeal is that I don't know whether this is the expression it is, but experience shows that those who are put in the sort of position that elders are may abuse that position and commit sexual abuse. That's certainly what the judge says in, is it paragraph 159 or one of those paragraphs at about that point in his judgment, and that's picked up by the Court of Appeal in their judgment. I can take so I could take your lordship to the paragraph.
I don't think 159.
No, it's later. It's later than that. I'm sorry. It's I suppose it's 163.
On page 163, aren't we?
Sorry, paragraph 163 on page 204.
Thank you.
Third, sexual abuse is almost always a form of abuse of power, whereas here the act of abuse involves physical violence. It would generally be enabled by the relatively greater physical power of the abuser compared to his victim. But acts of sexual abuse rarely happen out of the blue. Often the perpetrator abuses his own position or that of others to engineer a situation in which the abuse can occur. And then he refers to Lord Justice Longmore in Margaret, which I want to come on to deal with.
But this is a general statement about the conferral of power in individuals and its abuse. It's not making any judgment about the particular Jehovah's Witness organisation. It's a more general statement.
Yes.
Have we been able as yet to get a list of the tasks that were assigned to Mr. Sewell?
Well,
so that we can compare that to see whether there was any close connection with those tasks.
Well, my lord, so I knew that your lordship would ask me that. My submission with respect is that that's the wrong way of approaching this case, and that to look at the activity itself is not sufficient in this case. My lord, there has been some. I have dealt to a certain extent with the tasks which the elders have. They lead the Bible study. They conduct the meetings in the Kingdom Hall. They provide pastoral care. They provide directions to the congregation. And they exercise discipline over publishers with other elders. But their authority goes far greater than that. Their authority is all-encompassing in everything that they and the publishers do. And I do say with respect that simply to focus upon the activity would be, with the greatest of respect, the wrong approach to adopt.
Does that mean that you don't consider a case can be constructed on the basis of a close connection and the actual tasks that were assigned to the elder?
The one factor which Mr. Justice Chamberlain did identify, and the Court of Appeal did as well, was the fact that the four of them, the Sewells and Mr. and Mrs. B, had returned from a pioneering session that morning. That pioneering session, of course, was evangelizing perhaps the most important function of elders and
what
other
was
publishers.
The close connection between the pioneering session and the incident that took place?
Well, I do say there is. Can I come back to that? I can deal with it now if your lordship would like me to. I do say that in this case, because of the nature of the role and authority of an elder, there never came a time when Mr. Sewell, as an elder, to use the expression in Muhammad, metaphorically took off his uniform the moment he came back into his home. Can I test it in this way? If Mr. Sewell had been on a pioneering session in Bridgend, as I think it was, Cowbridge, thank you, not with BXB, but with a young female member of the congregation.
That seems most unlikely, if I may say so with respect. I mean, I thought that they were discouraged from having one-to-one relationships with persons of the opposite sex, and one assumes that discouragement is just as important in a pioneering session as it is during a Bible study.
Well, I think in fact...
also, if I may, I was trying to concentrate on the particular facts of this case.
Yes.
So one has a careful analysis of this case in contrast to the roles that are assigned. And so I'm not going to get much help, I don't think, from imagining another case.
Well, I understand that, my lord, but the point that I wanted to make was that the hypothetical case which I was going to give demonstrates that activity on its own is not sufficient. That one needs to look more broadly at the risk rather than just the activity, because if one were to replace BXB, and perhaps there were four of them, so perhaps the four of them go together, but with a young child, and they come back to his home with the young child, and Mr. Sewell were to take that child into the back room and rape the child, would it, with respect, really be being suggested that
would that then be analysed on the basis that he had been given physical care of that child? That was one of his assigned duties.
Well, with respect, I'm not sure that it is. Not sure that it's any part of the elder's functions to care for children, particularly young teenage girls.
Takes them, as it were, out of their own home environment, round various houses, knocking on doors. There's no aspect of care and control of the child.
Well, I'm not sure that is a role of the elders, and that certainly wasn't any evidence that there was.
But your case is that one should concentrate on risk as opposed to on the activities.
Activity can very well be important, but overall, it's bigger than that, because stage 2 can be made out in other ways other than just the activity.
Yes, I mean, you're saying the risk arises from an all-encompassing authority. That's the essence of your case.
Yes. Yes. And activity can very well be important, and in many cases, no doubt it is.
When you say he never takes off his metaphorical uniform,
yes.
That surely, in the light of an answer you gave me yesterday, has to be qualified to some extent, because I understand your submission to be never takes off the metaphorical uniform in relation to other members of the congregation. Because the example I gave you yesterday, if he never takes off his metaphorical uniform, when he's doing his window cleaning and injures somebody, I think you accepted there's no possibility of vicarious liability. Yeah. So it has to be qualified to that extent, I think.
Yes.
Yep. Thank you.
Can I... I was going to take you to Dubai Aluminium, if I may, to which you've already been taken. Can I take it shortly? It's page 511 in the bundle. And this is a passage, part of this passage you've already had read to you. Lord Nichols, at paragraph 20, sets out the facts of that particular case, which was, of course, a very different case to this. And he says at 21, however, this latter fact does not of itself mean that the firm is exempt from liability. Whether an act or omission was done in the ordinary course of a firm's business cannot be decided simply by considering whether the partner was authorised by his co-partners to do the very act he did. The reason for this lies in the legal policy. The underlying legal policy is based on the recognition that carrying on a business enterprise necessarily involves risks to others. It involves the risk that others will be harmed by wrongful acts committed by the agents through whom the business is carried on. When those risks ripen to loss, it's just that the business should be responsible for compensating the person who's been wronged. This policy reason dictates liability for agents shouldn't be strictly confined to acts done with the employer's authority. Negligence can be expected to occur from time to time. Everyone makes mistakes at times. It's a fact of life and therefore to be expected. He goes on in the next sentence, it's fair to allocate risk of loss, thus arising to the business, rather than leave those wronged with the sole remedy of doubtful value against the individual employee who committed the wrong. To this end, the law has given the concept of ordinary course of employment an extended scope. And then he goes on, it's important that I should read it, having referred to Morris and Martin, to say, in that case, perhaps the best general answer is that the wrongful conduct must be so closely connected with acts the partner or employee was authorised to do for the purpose of the liability of the firm or the employer to third parties. The wrongful conduct may fairly and properly be regarded as done by the partner whilst acting in the ordinary course of the firm's business. And then he refers to the passages that I've referred you to by Lord Millett in Lister, and then to Lord Steyn, and then Justice McLaughlin in Bazley. The policy purposes underlying the imposition of vicarious liability on employers are served only where the wrong is so connected with the employment that it can be said that the employer has introduced the risk of the wrong. All of those cases, Lister, Dubai and others, of course, follow on from the Canadian cases decided a little while before in 1999. Indeed, they become the starting point of any analysis, certainly on stage 2. Indeed, in Lister, at paragraph 27, Lord Steyn went so far as to say that these cases should be the starting point of any analysis whenever these points are being considered. There's a passage from Bazley. Unfortunately, we don't have Bazley in your bundle, but we do have the relevant passage in Marga. Can I invite you to turn to page 673 in the bundle?
I'm not sure the other members of the appellate committee agreed with Lord Steyn about that, did they? I have a recollection that Lord Clyde was rather keen to distance himself from the Canadian cases.
I think your lordship is right in relation to Lord Clyde. Can I take you to paragraph 84?
The statement of principle there would be acceptable if you added in the words by assigning tasks to the employee. The policy is the employer has introduced the risk by assigning tasks to the employee, and so then you then concentrate on the particular tasks.
Yeah. And if I may say so, the whole point, very much one of the points of Morrison's was to get away from what Justice McLaughlin said in the passage quoted by Lord Nichols in paragraph 23 of Dubai. You'll see this was part of the argument, one of the issues in the case. You'll see in paragraph 23, the answer that Lord Nichols gives is that the wrongful conduct must be so closely connected with acts the partner or employee was authorised to do, that, etc. So the focus is on specific acts that he's authorised to do. Now, McLaughlin J's dictum from her judgment refers to the wrong being so connected with the employment that it can be said the employer has introduced the risk of a wrong. Now that's very much not the approach being adopted even in Dubai, and certainly not, or by Lord Millett in Lister, and certainly not by this court in Morrison's. So, Bazley and Curry is not the test applied in this country.
Well, my lord, the point that I'm making from wherever it comes, is that one needs to look at this more widely than just looking at the activity in this sort of case. And yes, what Lord Nichols says in Dubai Aluminium may well apply to that sort of case, which was a very different one when one looks at the activity. But to look at it simply in terms of a list of what are the activities which the employee is authorised to do, and is there a close enough connection with that, is, in my submission, not sufficient in this sort of case, because
so you say this sort of case requires a different test from the one adopted in Morrison's. So we need to know, how do we define the class of cases that falls outside Morrison's, and what do you say the test applicable to that category of cases?
Well, I don't say, as I said at the beginning, that this is a different test. It's just a different way of applying the close connection test. It's more nuanced, open texture, as the judge said. And one needs to look at other factors in a case such as this, such as the extent of authority and status and so forth, because that fundamentally is why, if I may say so, Mrs. B found herself in that room with this man.
Well,
his status
the function
as well.
of this court is to give guidance to lower courts and the legal profession. We need to find a form of words. It rather sounds as though you're telling us that what should be adopted is some sort of multifactorial test, where you take account of a range of factors. If that's the position, we need to be able to say that's the nature of the test, and these are the factors you should be taking into account.
Well, my Lord, my submission that it all comes down to the creation of the risk. And that's the fundamental point in this case, and that should be the test in these cases. And the creation of the risk can have been created in a number of ways, one of which is looking at the activities. Another, in this case, is the extent of the conferral of authority, the extent to which a congregant, a publisher such as Mrs. B, would feel that she must do what she's being told by the elders to do.
So it was made clear in Morrison's, following earlier cases, that the creation of the opportunity for wrongdoing, which is another way of talking about creation of a risk, wasn't enough. But you're saying that is the core of the test for a particular type of case. So what's the type of case that test applies to?
Well, the cases involving sexual abuse.
Slightly puzzled at the moment as to why you see any difficulty with tying your submissions to what were the acts that the defendant was authorised or given special authority to do. I mean, why is that presenting you with a difficulty? Because that's only a more specific analysis as to what the akin to employment elements are, surely. And yet you seem to be resisting that it's a close connection to what he's authorised to do. I mean, to put it this way, why can't you say, well, he's authorised to counsel people, he's authorised to offer spiritual advice to people, and it was in that context that this sexual abuse took place? I'm not at the moment seeing why you seem resistant to the idea that this is linked, almost closely connected to activities, etc., that he's authorised to do.
Well, the factor which was identified by Mr. Justice Chamberlain and by the Court of Appeal was the fact that the four of them had been pioneering, and that, of course, was preeminently the role that they all had, and elders had the task of leading, and that had just happened. And in my submission, that is an activity which I would say is sufficiently closely connected to the role which an elder had, As to counselling and
is close connection not to the role of the elder, is close connection between the role of the elder and the act he commits. And
yes.
I mean, to take Lord Borough's example, if he was, one of the matters assigned to him was to counsel people, you could imagine circumstances in which he could abuse that power, that authority, by inviting somebody to come to his home to be counselled and then to commit a sexual assault.
Yes.
That would satisfy the closely connection test, potentially.
Yes, that would be an example of an activity.
What I want to do is try to find out how the actual roles that he was assigned were closely connected to this tort.
Well, first off, I do say that the fact that the four of them have been pioneering is an activity, and that is sufficiently closely connected because they had returned because of the state in which Mr. Sewell had become. They had returned to his home, and they were all there. She had stayed there with her husband because of that, and that is sufficiently close connected in itself. But I'm sorry to keep coming back to it, but I do say that a factor in this case is the influence of authority, which he had as an elder. And I come back, if I may, to the point made by Lord Phillips in Christian Brothers at page 338.
Just before you leave that, sorry, you were going to take us to the passage in Baisley. I've not actually got the passage in front of me, but is it the one at paragraph 86
yes.
on page 673?
Yeah.
Well, what that says is, this requires trial judges to investigate the employee's specific duties and determine whether they give rise to special opportunities for wrongdoing.
Yes.
Isn't that all we're asking? We're, in a sense, putting to you in relation to what acts is he authorised to do. They are the employee's specific duties.
Yes.
Are they not?
It is, and the passage goes on, of course, because of the peculiar exercise of power and trust that pervade cases such as child abuse. Special attention to be paid to the existence of a power or dependency relationship, which on its own often creates a considerable risk of wrongdoing. And that is picked up in the passage to which I was going to take you from Christian Brothers at paragraph 84. Page 739, where the Lord Phillips says, where those who abuse children have been members of a particular church or religious order and have committed the abuse in the course of carrying out activities in that capacity, claimants have had difficulty in establishing the conventional relationship of employer-employee. What has weighed with the courts has been the fact that the relationship has facilitated the commission of the abuse by placing the abusers in a position where they enjoyed both physical proximity to their victims and the influence of authority over them, both as teachers and as men of God. He goes on to deal at paragraph 86 with the Canadian authorities and the reference to creation or significantly enhancing the risk. And at 87, finally, these are the criteria that establish the necessary close connection between relationship and abuse. I don't think it's right to say that creation of risk is simply a policy consideration and not one of criteria. Creation of risk is not enough of itself to give rise to vicarious liability for abuse, but it's always likely to be an important element in the facts that give rise to such liability. And so I do say that in looking at this, you do need to look beyond the tasks which the role gives to the tortfeasor, in this case the elder, it must be closely connected to the risk associated with the role which had been assigned, and to relate it to specific tasks only would, we submit, lead to the potential for rather perverse results. Can I give an example related to the case of FZO, which is in your Lordship's bundle, at page 615. That was a case involving a teacher, and you'll see from the bottom of 615, this is the Court of Appeal for Justices McComb and Simon and Lady Justice Nicola Davis. The teacher, right at the bottom, pleaded guilty to counts of indecent assault and buggery when the respondent was aged between 13 and 15 and admitted raping him when he was under 16. The local authority accepted vicarious liability between 80 and 82 when the respondent was a pupil at its school, but maintained that he'd consented to all activity thereafter. The respondent reached his majority in September 84, had ongoing contact with the teacher until 2011, when after years of anxiety and psychological problems, he suffered a breakdown. He began proceedings in June 2016, 25 to 30 years after the expiry of the limitation period. The judge, at first instance, disapplied the limitation period, ruled that the respondent had submitted to the sexual activity rather than giving true consent, and the local authority was vicariously liable excuse me, for the teacher's actions, as the connection between his employment and his wrongful conduct had not been broken after the respondent left school. And then dealing with vicarious liability towards the bottom of the page in the held section. The local authority maintained that the relevant relationship was not sufficiently close to support a finding of vicarious liability, as the respondent was not a pupil in the later stages of the abuse. And even when he had been a pupil, the abuse had taken place in the teacher's private time and not at school. Each non-consensual sexual act would have been potentially a separate tort, but the instant court was loath to disturb the judge's evaluative judgment that the teacher's abuse of his position of trust in the period up to the respondent reaching majority continued to operate on the respondent thereafter, so that his participation in subsequent sexual activity had been submissive, not consensual. The different aspects to this abuse. The first act of abuse took place in the teacher's car whilst he was still a pupil at the school. That can be found at paragraph 15 in the judgment. For brevity, I won't take you to it. Abuse then took place both on and off school premises, including on an entirely privately arranged sailing trip. That's paragraph 17. And then continued after the claimant left school and into adulthood. And the Court of Appeal upheld the trial judge's decision that the defendant should be vicariously liable for all of the abuse. Now, if in my submission one simply applied a task-based analysis, then the defendant would not be liable for those acts which occurred outside the school environment, and certainly not liable for assaults which took place after he left the school. And I do say that applying the activity-based approach it may be important, it may be the factor, can bring about both inconsistency and unfairness in results.
Where do we find the Court of Appeal's reasoning in this?
If your Lordship goes on to the long judgment, I will.
One interpretation, they were responsible for all the damage that flowed from the initial torts that were committed whilst he actually was employed.
Obviously, the stage 1 test couldn't be satisfied after he was no longer employed. So there would have to be a different approach to the case, as I mean, maybe it's wrongly decided, of course, but if it's not wrongly decided, it has to be on a basis which can't be relevant to this case.
I'm looking for the passage where the Court of Appeal deal with vicarious liability. I apologise. Thank you very much. Yes, it's 6-4. Thank you. The Lord Justice McComb, I think, sets out paragraph 140, set out above the crux of the judge's decision on this issue, in which she sought to apply the two-stage test. Two stages of the test are correctly identified. This is paragraph 142 in paragraph 70 and 71 of the appellant's skeleton argument. For stage 1 to be satisfied, there must be, and then we know that test. And then his lordship refers to Lord Toulson in Mohammed, and goes on to refer to Warren and Henley's, and then to the school's arguments from paragraph 144 and 145. And at 149, the law relating to vicarious liability has been on the move, even since Lister, referring to the judgment of Lord Justice Ward in the Court of Appeal case. And then he sets out that passage from Lord Phillips. And then deals, for example, at 150, the fact that the acts in issue may be committed away from the workplace may well be regarded as less relevant today. And then perhaps it's 153. I agree with the appellant that each non-consensual sexual act committed by the first defendant on the respondent would have been potentially a separate tort. But the question posed by Lord Phillips still arises even in the period up to 88. Was it the abuse of the position of trust created in the period up to 84, and undoubtedly within a relevantly close connection, that was still operating upon the respondent? The judge answered this question in the affirmative at paragraphs 218 and 9 of her judgment, and I'd be disinclined to disturb that evaluative judgment of a trial judge. And then his lordship refers to Lord Dyson and Lord Nichols in Dubai Aluminium.
That seems to be the key, that the abuse of trust while in employment was still operating, explaining the submissiveness of his activity rather than involving adult consent.
Yes. And in a sense...
Also, it seems to be critical that the court wasn't treating the incidents of abuse as distinct torts. Because obviously the tort committed years later, years after the young man had left school, wouldn't be committed in the course of a teacher's employment in any sense. So it has to be treated as some sort of course of conduct, I think. Well, it's a case that gives rise to enough problems on its own. Yeah, what do you take from it for this case?
Well, the point that I make is that if one simply analyses it on the basis of activities, then the abuse, certainly when the respondent had left school, would not have been a finding which the court would have made.
Yeah.
I don't put it.
Well, that's maybe the right answer.
I'm sorry, my lord.
That may be the right answer. Maybe the decision's wrong.
Can I move on then to...
I'm really struggling with this submission because this is an unusual case, clearly, where you've got a situation that started off that's then carried on. But there's no problem linking what initially happened to the duties assigned to the particular school teacher. And then you've got a question is, well, because that's already happened, can we count what happened later on as similarly linked to what was assigned, the duties assigned to the teacher? So it doesn't seem to me that there's an issue about whether it should be carrying on, but I'm not sure that I see why your belief that this case can't be explained by an assignment of activity type approach. I'm just not sure I follow that.
Well, can I address that by taking lordships to the case of Margar, which I've been saying I'm going to do for some time.
This analysis.
And I'm there now. Margar is at page 658 of your bundle, and I don't think you've been taken to the facts of this case, so can I do so very briefly at 658? This was the somewhat unusual priest. The claimant who had learning difficulties and epilepsy brought a claim against a Roman Catholic archdiocese for damages for personal injuries, alleging that he'd been sexually abused as a child some 30 years earlier by a priest who lived and worked in the archdiocese. The claimant wasn't a Roman Catholic, but had met the priest, who had special responsibility for youth work through church discos open to all young people and so forth. Claimant alleged that 1 year before he'd been abused, I think that relates to the negligence claim, the complaint by another, so I shall pass over that. The judge, reading from the last sentence, I think the judge dismissed the claimant's claim, holding that the claim was not time-barred. The archdiocese was not vicariously liable for that abuse, and that although the priest and thus the archdiocese had been negligent in not taking the reports of abuse further, the archdiocese owed no duty of care. The appeal was allowed, although the archdiocese had no direct responsibility for the claimant as a non-Catholic. A number of factors taken together established a sufficiently close connection between the priest's employment as a priest at the church and the abuse which he had inflicted on the claimant to render it fair and just to impose vicarious liability for the abuse on the archdiocese as the priest's employer, including the fact that the priest had had a special role of trust and responsibility and a degree of moral authority. The claimant's youth and the priest's special responsibility for youth work among Catholics and non-Catholics, the development of the priest's relationship through his youth work at the school, at the church, which led to the claimant's work for the priest, both on and off church premises, and the priest's opportunity to spend time alone with the claimant in the presbytery without supervision, all of which arose from his employment by the archdiocese, and that accordingly, since the archdiocese was vicariously liable, the claim succeeded. And this was a case, of course, where stage 1 employment was conceded, so the court was dealing simply with stage 2. The first judgment is given by Lord Newburger, or Master of the Rolls, and he sets out in some detail the facts beginning at paragraph 5. I won't read them for brevity, but they're important, and goes on at paragraph 37 to deal with Lister and Hesley Hall, and the judgments in that case, and then the Canadian judgments. It says this at paragraph 45. First, Father Clonan was normally dressed in clerical garb, was so dressed when he first met the claimant. At the very least, this factor at least sets the scene. A priest has a special role which involves trust and responsibility in a more general way even than a teacher. He's in a sense never off duty. He'll normally be dressed in uniform in public and not just when at his place of work. So too he has a degree of general moral authority which no other role enjoys. It was his employment as a priest by the archdiocese which enabled him, indeed was intended to enable him, to hold himself out as having such a role. His duties included a duty to evangelize. Thirdly, the claimant was 12 or 13, and Father Clonan was given special responsibility for youth work. And fourthly, the claimant was drawn into the relationship through the medium of a church-organised function. And then his lordship refers to the Jacobites, the Canadian case of Jacobi, and then to the judgment of Lord Justice Longmore, to which I want to turn, if I may, because there's an important passage I would submit, beginning at paragraph 83 on page 673, where Lord Justice Longmore says this: in the case of the Roman Catholic Church, this situation is further emphasized by its claim to be the authoritative source of Christian values. For centuries, the Church has encouraged laypersons to look up to and indeed revere their priests. The Church clothes them in clerical garb and bestows on them their title, Father, a title which Father Clonan was happy to use. And then at 84, what is said in this present case is that while the Church would accept responsibility for abuse of an altar boy, and probably a member of the congregation, this case is different because the victim of Father Clonan's abuse came into his ambit in a non-church manner, by various examples that he gives. And then he goes on, but the progressive stages of intimacy were, to my mind, only possible because Father Clonan had the priestly status and authority, which meant that no one would question his being alone with the claimant. It's this that provides the close connection between the abuse and what Father Clonan was authorized to do. And in my submission, that's exactly the same here. If it suggested that cultivating a friendship with the respondent, as it was at one stage by the appellant, was not within an elder's field of activities, that, in my submission, misses the point made by the trial judge and by Lord Justice Longmore and Lord Neuberger, in fact, in Marga. The activities which he was authorized to perform in his role here as an elder and the status which he held was what gave rise to the risk that he would abuse his position by developing the progressive stages of intimacy, just as the priest was able to do in Marga. And I started, as we've already said, the role of an elder is all-encompassing. The publishers are, the elders are the shepherds. Their authority comes from Jehovah. There's a requirement on the part of publishers to be obedient and submissive, and they involve themselves, the elders involve themselves in all aspects of a publisher's day-to-day life. And Mr. Sewell manipulated the role which he had been given, the power that he'd been given. His abuse of that role became increasingly intrusive and I say disgraceful. First of all, by making a point of kissing female members of the congregation on the lips, something which the elders allowed to happen and go unremarked. And there's evidence, not challenged evidence, that from BXB that other elders saw that happen. Now, that was described with respect by my learned friend as being, well, something which was just being over-familiar. With respect, that hardly does justice to how that is likely to make somebody like Mrs. B feel. Mrs. B's evidence about that is in her witness statement at paragraphs 31 to 32 in the core bundle at page 357. She felt extremely uncomfortable, but more importantly, could do nothing about it. She thought about complaining, but that just caused a fuss. She told Mary Sewell, Mr. Sewell's husband, in fact, Mary Sewell came back to her and said that her husband had reacted indignantly when she'd raised it with him. Next stage of the progressive stages of intimacy, he started to flirt and to make sexual innuendos, and there was further unwanted physical contact. She describes that in her witness statement at paragraph 36, which she was powerless to prevent. And it's because of his status as an elder that this was allowed to happen. And he was able to get away with it because he was an elder and there was nothing that Mrs. B could do to prevent it. And then eventually he asked her to run away with him before the final stage, which was the rape at his home of Mrs. B. And every case of vicarious liability, every relationship in my submission must be analysed on the fact. But in this case, such was the power and authority of the elders, which the Jehovah's Witness organisation had given to them, that Mrs. B could not escape him. He was part of her life because of his status as an elder. He misbehaved because of his position of power, which he could abuse. And that was an inherent risk associated with his appointment as an elder, because of the way elders are treated as having God-given authority. Mrs. B wanted to escape that relationship. Indeed, at one point she considered doing so. The only way to escape Mr. Sewell would have been to leave the organisation. And that's not comparable to a decision perhaps to move to a different congregation, as might be the case in a church. Because at the very least, if she'd moved home or joined a different congregation, there was a risk that she would be shunned, as indeed went on to happen, and eventually lead to the breakup of her family. And those risks all come into play, not because of any particular activity, although, of course, the progressive stages of intimacy began with something which Mr. Sewell was able to do as part of his duties, namely greeting members of the congregation at the Kingdom Hall. But those risks come into play because of the risks inherent with the power that assigned to elders in the context of the way in which Jehovah's Witnesses' life in the congregation will operate. And so, coming back to the judgment of the trial judge in the Court of Appeal here, they both applied in my submission the correct test. I've set out already the trial judge's conclusions at paragraph 173 and thereafter. I invite you to reread those. Can I just take you, first of all, next to the Court of Appeal, and in particular, if I may, to, first of all, to the judgment of Lady Justice Nicola Davis at page 139 in your bundle.
If I may say so, the abuse of authority is very much a feature of cases like MAGA that you've taken us to, where effectively a process of grooming takes place and then culminates in sexual behaviour to which the child or the person with learning difficulties submits. In this case, you might want to try to characterise what was going on as an attempt at grooming.
Yes.
But the analogy breaks down at the stage of the tort, because it's not, what we're talking about is a violent rape of an adult woman.
We're talking, with respect, about the violent rape of a vulnerable 29-year-old woman.
But her vulnerability didn't... what part in the rape did her vulnerability play?
Her vulnerability arises out of the fact that she is dealing here with a man who has such authority and status over her.
But she doesn't submit. She's not like I mean, the cases you've been taking us to are cases where children submit to sexual assaults because they're overawed or trusting or otherwise have been gradually made accustomed to the idea of sexualized behavior with an adult, and so they go along with the behavior of the abusive adult. Here, this poor woman was simply attacked and raped. It's not apparent how the fact that this man kissed women at the church, for example, has anything to do with his attacking the claimant.
If this were simply a case, and none of the earlier stages of intimacy, I would suggest, whether you call it grooming or whatever, if this had been just a case of him out of the blue raping Mrs. B, and that might very well be the case. But that isn't with respect to this case. And whether one calls it grooming or whether it calls it intrusive intimacies because this is an adult, it's the same in my submission. What this man is doing is abusing his position, first of all by kissing on all females on the lips, and then moving on to sexual innuendos, trying it on, seeing how far he could get, physical contact, and leading on to a suggestion that they should run away together, and then eventually raping her. And in terms of submission, with the greatest of respect, it isn't always the case that children necessarily, because of the grooming, submit. Very often they don't to submit. The opposite. And Mrs. B was hardly in a position, with respect in this case, to resist the assault by.
Nobody is suggesting she was under any duty to resist. What I'm trying to find is a connection between what you're calling grooming and being attacked, as it seems, entirely unexpectedly when the two of them were in the house.
But they wouldn't have been there. With respect, she wouldn't have had anything to do with him. The most important finding of the judge was that this rape would not have occurred because she would not have been there, but for his status as an elder.
Yeah. So it's a but-for cause.
And so none of this would have arisen. She wouldn't have put herself in a position, had it not been for his position and status as an elder. That's a factual finding which the judge made on the evidence which he heard. He heard from her and he accepted her evidence.
If we were to take a view that it was entirely unexpected, that it was out of the blue, it wasn't just a natural progression of intimacy equivalent to grooming, I take it that at that point you would accept that there's no vicarious liability.
Well, save that I rely upon the fact that they've been out pioneering together. And again, I appreciate that every case is different, but if this had been, let's just take an example of a child sexual abuse. If the situation had been that BXB wasn't a 29-year-old adult woman, but had been a 15 or 14-year-old girl out pioneering with her parents and with Mr. Sewell, and had come back and had found herself in a room on her own, then that would have been a strong case of vicarious liability in my submission. And there's no, with respect, there isn't any difference here between that case and this. To draw a distinction is, with respect, illogical. Given what we know about how the Jehovah's Witness organization require not just children but adults to respect and be obedient to the elders. And it's a very particular set of circumstances, perhaps unique to the Jehovah's Witness organization, that one finds oneself here. This is an organization which sets up their elders to have a position of such authority, more so you may think than the Catholic Church, of authority over the other members of the congregation, that they should adhere to every direction that they're given by the elders.
It slightly depends, or you may think it slightly depends, as it were, from which end of these awful events, which end of the telescope you look at these events. On one view, albeit no doubt because they were all Jehovah's Witnesses, Mrs. B and her husband, and Mr. Sewell and his wife, had formed a close social friendship which led them to going on holidays together, presumably going out to meals together, spending afternoons with their children, in each other's homes. And if one looks from that end, the notion that within that context Mr. Steele is still wearing his elder's garb looks a bit odd. It looks as if it's been replaced by a close social friendship that had its origins in the church but was self-sustaining.
Well,
whereas if you look at it from the end you're asking us to look at it in, they go out pioneering in the morning and then they go back to his house as if it's some sort of tail end to a piece of pioneering.
Well, except, say for this, the first end of the telescope, the relationship would have ended, the friendship would have ended, but for the fact that he was an elder. That was the evidence, and that was the finding that the judge made. So, yes, it had grown up as a friendship, although even then, the fact that he was a ministerial servant, as he was when the friendship began, but the relationship, the friendship would have ended, but for the fact that he was an elder. And so it's not quite as simple as that in this case. I can find the reference in the judgment if your lordship would like me to, but it's in those factual findings which the judge makes.
No, I recall it.
I think I've run out of time.
I'm afraid so, Mr. Counsel, but I think you've covered everything.
Thank you.
Your thoughts?
My lords, may I start with the role assigned to Mark Sewell, and that's a theme that's emerged, I think, from some of your lordship's questions, in particular Lord Stevens. There's no evidence that he had any particular role assigned to him in BXB's evidence, and she knew him well. She didn't suggest otherwise. So the evidence of the role of an elder came from her, from FXC, a former congregant, whether he was disgruntled or not, but a former congregant, and Andrew Schofield, the ecclesiastical expert, whose evidence was entirely accepted by the judge. And there are one or two short points I'd like to, I hope, assist the court with about certain questions that arose during yesterday and today about the way that elders and indeed Jehovah's Witnesses live their lives. May I take the court to page 351, which is to do with good association. This is Mr. Schofield being cross-examined or examined, and just above letter F we have his answer. On a number of points, first of all, we are recognised and have been a number of times by the European Court of Rights as being human rights, as being a recognised Christian denomination, and certainly we encourage good association, those who will have a positive influence on our relationship with God and our qualities. But the idea that we do not associate with anyone else is simply not true. And if I may give my own personal experience, and he was a very experienced elder, my family are not Jehovah's Witnesses, mostly Catholic or nominally Catholic or practicing, and I freely associate with my brothers, my mother, my father is now dead, my sisters and all relatives. I was best man at my brother's wedding in a Catholic church. I was at my other brother's wedding in the Church of Scotland. It's simply not true that Jehovah's Witnesses have no association with non-believers. So we would submit that it's not correct that association is so limited as suggested by my learned friend. And in the course of her evidence, BXB accepted that she went, why shouldn't she, to concerts on holidays and had dinner parties, and it wasn't suggested that she always went with Jehovah's Witnesses. Learned friend also relied on the fact that women were generally not encouraged to work. In fact, she gave some evidence of that, which is at 229. Just below letter C, many men and women in the organisation have full-time jobs, don't they? Now they do. Well, they did then. Not to my knowledge, no. Well, women, perhaps generally now, in all walks of life, work more than they used to. but that's not a reflection of any instructions or attitudes of the witnesses, is it? I think the way they put it to you is it's not a direct instruction, that one that plays on your conscience in order to be a good Jehovah's Witness. And she told the court, and there's no dispute about this, that she did about 5 hours pioneering work a week. She was married with children and had a part-time job. And she also said that many women in the organisation had full-time jobs. She said that she was friends with everybody at the Kingdom Hall. And the evidence, which we can get at 231, sorry, it's 230 at the bottom of the page. She was just asked about the fruition of their friendship. You became friends at the point at which you became an elder, and she said at the bottom of the page, letter G, we were already friends. I was friends with everybody in the Kingdom Hall. And over the page, we were all the same age. This is just below letter C. We had 2 children. Each of our children played nicely together. We went on holiday together. They came to our house for tea. We went to their house for tea and went on days out together. We had lots in common with them. We went to concerts and we had a lovely family friendship. And after a while, Mark went into hospital, etc. So that perhaps gives a slightly different impression than was originally suggested in terms of the degree to which being a Jehovah's Witness dominated her life. The subject of grooming has come up in various contexts. Lord Justice Mayall's comments are worth revisiting. I don't ask the court to do it now. He did not seem to accept that there was grooming in any of the traditional understanding of that word. His approach was not, has to be said, entirely consistent with the analysis of Lady Justice Nicola Davis. Lord Justice Bean's observations were very robust and brief, probably not intentionally, because the matter had been dealt with by other judges, detailed in terms of the analysis of the case, although I noticed that my learned friends begin their printed case by reference to it. It's a comment about religious organisations as a whole. With great respect, we are looking at a particular religious organisation just as one looks at a particular arrangement to decide whether or not there is a case where there should be vicarious liability or not. My learned friend has made a lot of the gradual build-up, as it were, of the relationship which she relies on, dealing with the kissing and the flirting and the like. There is some evidence on that, which can be found at page 246, just at letter E. Him kissing you, what did you think? All Jehovah's Witnesses greet each other with a kiss. Females will kiss each other on the cheek. Some males will kiss you on the cheek, not all, some. He took it one step further. So until the criminal offence was committed, are you saying that he didn't behave in any way for you to view it as abusive? Not abusive, no, flirty perhaps, stepping over the line. But even there, did you see anything sinister in his flirty behaviour with me or with others? With you, no, not sinister, no. So, but learned friend is skillfully painted a picture of a gradual build-up, but we submit that it's a rather hard submission to justify on the actual evidence. Is an elder never off duty? He compared the position with a parish priest in E. We submit that that is not a fair comparison for the reasons we've set out elsewhere. He pointed to the fact that one witness said, although this is not in the facts and issues, statement of facts and issues, and this witness was FXC, said that elders advised congregants on what films to see, what clothes to wear, and so forth. Those points were not put to Mr. Schofield, and they're not part of the statement of facts and issues. That was certainly a view of a witness who I accept that the judge thought was a helpful witness. May I come to the central issue of risk, which has featured very largely in the argument today. My learned friend referred to what Lord Millett said about risk. I don't take the court back to it. You're very familiar with what he said about the particular circumstances in children's homes and other cloistered circumstances. Risk, we say, is really not part of the analysis on stage one. Risk is, however, relevant, we submit, as part of the analysis on stage two, because if a court is deciding whether there is a sufficiently close connection with what the employee is authorised to do, then the inherent risks of the job will be a factor in the analysis of whether there is a sufficiently close connection. That's what the risk which was being analysed in Lister was, and particularly in the passage which Lord Millett pointed out. But it's difficult to know how the risk really illuminates the question at stage one at all. And from that I move on to the use of the word synthesis, something that I think has troubled many commentators, and certainly those like advocates before you who've laboured in this particular vineyard, as to quite what it means. Does it mean you throw everything up in the air and take a factorial or open texture test? And how do you borrow from one part of this stage to another? We respectfully submit it isn't really helpful to do that, and we would invite the court to say that the synthesis perhaps is no longer part of the overall approach, which was the approach which, of course, seemed to come from Catholic welfare case. And I do remind the court that when Mr. Justice Chamberlain was looking at this case, that seemed still to be the law insofar as it was clear what it was saying. He had not the benefit of the two cases, Morrison's and Barclays Bank. Can I take the court to our printed case? Which is at page 41 in the key documents bundle. Where we deal with the question of applying the stage 2 test correctly at paragraph 94.
Paragraph?
94. We refer to the Morrison case, where we say the test to be applied is whether the wrongful conduct was so closely connected with the acts the employee was authorised to do for the purposes of the liability it may fairly and properly be regarded as done by the employee while acting in the ordinary course of his employment. And we say that the test is not based on causation or timing and the mere fact of an opportunity. It's not sufficient, and the motive is plainly important in determining whether he was engaged, however misguidedly, in furthering the employer's business or on a frolic of his own. If, on the other hand, and your Lordship has our submissions, that stage 2 is not different in sexual abuse, but there may be factors in sexual abuse or other cases which are relevant to the application, but it's not per se different. We say that the Court of Appeal were wrong in the way they approached it. They failed to consider that the common denominator in most, if not all, of the cases of sexual abuse where the close connection was found to be satisfied, where the abuse took place in an institutional context, where the tortfeasors were entrusted with the physical care of the child, physical proximity, in some cases also physical touching, and an expectation the tortfeasor would develop an emotional bond with the child. And that's the Christian Brothers case. And we say none of these indicia, paragraph 97, apply to the present case. She was an adult woman who had her own home and family, and the Barry congregation did not have, of course, physical care or control over her, nor did it require Sewell to develop an emotional bond with her. And we refer to the case of Jacobi, which of course is the other side of the coin. Now, the Canadian cases, though illuminating, are not binding on this court. But in Jacobi, we quote what the Supreme Court said, that there must be a strong connection between what the employer was asking the employee to do, the risk created by the employer's enterprise, and the wrongful act. It must be possible to say the employer significantly increased the risk of the harm by putting the employee in his or her position, requiring to perform the assigned task. We say, in fact, that's consistent with the approach which we say properly can be derived from Lister. The question of the two being alone, as I think was pointed out in argument, is very much not part of the Jehovah's Witnesses' approach to communications between congregants. The statement of facts and issues makes that clear. And it's page 7, paragraph 19. Of Jehovah's Witnesses endeavour to live up to the Bible's high moral standards. Elders must never, little a, provide pastoral or other assistance privately to a member of the opposite sex who is not the elder's marriage mate or close family member. There is no permitted exception. Any assistance must always be provided in the company of another person, usually another elder. Married adherents are specifically cautioned against associating alone or developing close friendships or a close friendship with a member of the opposite sex to whom she is not related or married. Never any requirement to act as a confidant. Adherents, and then it goes on to deal with alcohol. Adherents are encouraged to choose good associates and are specifically cautioned against associating with anyone, including those within the congregation, who engages in scripturally improper conduct. And just going up the page, whilst the court's eyes are on this, paragraph 18 records that at the relevant time between 130 and 160 persons attended the service of the Barry congregation, of which approximately 17 men were elders and 20 men were ministerial servants. So that's a total of 37 out of between 130 and 160. Most, if not all, were married and had children, so there would have been quite a lot of children. So a considerable proportion, it's reasonable to assume, of that congregation had some sort of position, as it were, in the congregation. So this is not a question of someone, a priest, elevated above the rest of the congregation, and all members of the witnesses are equal to have equal respect. No doubt senior elders are regarded by some with greater reverence than others, but these are human beings, and the way they respond to one person may be different from another. But perhaps that gives a picture of what a congregation can be like. During the course of the argument, the question was, well, is there a liability for any tort committed in the course of employment, presuming there is employment, which we of course say there is not. This was a case of sexual abuse for the reasons that we gave. We do not submit that sexual abuse is ipso facto different. We do raise perhaps the rhetorical point. What if, as a result of what had happened on that day, there had been a punch-up between the two men, and because of a disapproval of his behaviour, and there had been serious injury curtailed? Would that have been a sufficient connection? And we say plainly not. The events of that particular day are important in examining the close connection. The learned friend relies heavily on pioneering. Yes, they had been pioneering, and that's an obligation of all Jehovah's Witnesses of whatever status. They're preaching together in the morning. Then at noon they go back to the public house for lunch. Sewell drinks too much and gets into an argument with his wife. The early afternoon he storms out of the pub. Mr. B goes looking for him. He then says he wants a divorce. Later afternoon, they pick up their respective children and go to Sewell's home. I think Lord Justice Mayles made it clear he didn't regard the home as having any special status. It wasn't as if it was a religiously approved area. And late afternoon, Mark Sewell goes into the back of the room, and his wife and BXB's husband asked her if she could talk some sense into him. Those were the circumstances in which it happened. He was obviously clearly intoxicated, having been into the pub. They knew each other well. No doubt their relationship, as she told the court, was coloured by their belonging to the Jehovah's Witnesses and coloured by the fact that he was an elder and had been a ministerial servant. He'd only been an elder for 9 months. But we submit it cannot be said that there is anything like sufficiently close a connection between what the dreadful assault on BXB and the roles that he was assigned and did in fact perform. In MAGA, the learned friend referred you to various paragraphs. He did actually rather stop at one particular paragraph. I don't suggest anything remotely sinister about him doing that. He had a lot to read. But when dealing with all the various factors which made it appropriate on those facts, said the court, you need to read all the various different factors between paragraphs 45 and 50. This was we would submit MAGA, a marginal case. And of course, the judge at first instance had found insufficiently close connection. This was a case of a priest who was clearly employed, who had authority in terms of his garb and his status, and a big age disparity between the claimant and him. He invited the claimant into the presbytery, clearly a religious area, so that, as it were, clothed what happened with some sort of quasi-religious context. And he was specifically assigned a task of looking after youths, and that is important. And to pick up the point made by my Lord Stevens about assigned a task, here he was assigned a task. No similar task being assigned to the elder other than his general role as an elder with the obligations and the expectations that begins and involves. The case of the Manchester City Football Club hasn't been referred to in any great detail. This is a first instance decision. I'm afraid that we made a mistake by putting in the wrong first decision, first of all, but I think that was corrected a couple of weeks ago so that you do have the decision of Mr. Justice Johnson. This was a case about Barry Burnell, who was a coach, and the facts have some similarity into the Blackpool Football Club case. The claimants were aged between 10 and 14, so they were children again, had played football for teams run by the coach, and he sexually abused them when acting as a scout and a coach. And the judge considered the vicarious liability relationship between the coach and the club. He considered all the relevant factors, but took into account, of course, all the authorities. And in the head note, we see under vicarious liability the relationship between coach and club. He refers to relevant factors, including whether he worked solely for the club, whether profits or losses accrued to the benefit, detriment of him or the club, whether he owed the club a duty of obedience. His role as a scout, going down the page, was voluntary, unpaid, and devoid of legal obligation.
Sorry, which page is it? I'm
so sorry. This is the head note, which would come after 275 and 276.
Thank you very much indeed. Thank you.
Nothing to suggest the club had been able to control how he undertook the coaching activities. And the court didn't find any connection or sufficient connection between the abuse and activity authorised by the club. Now, all these cases turn on their facts, of course. And the reason that both these cases, both football cases, are quite helpful, we submit, is they are an illustration of the test, since it's been clarified, working well in the terms of the courts are going to apply the test to the particular facts. May I refer just to 2 paragraphs from that judgment, which is, the paragraphs are 333 and 334.
Do we have a bundle page number?
I think this is a separate document. It was lodged, lodged yesterday.
This was the one that came separately.
TVZ against Manchester City.
It's page 65 of the document, yes.
65?
68.
It's 333 and 334. I do apologise for this.
Page 68.
Thank you, I'm most grateful. Mine to 65. It begins, nevertheless, there is a world of difference.
Yeah.
Nevertheless, there is a world of difference between the retention of a football coach and a teacher at a residential school. The latter is responsible as an inherent part of the job for the welfare of children in the school's care for 24 hours a day. They live in the same accommodation as part of their job. The abuse of children who have been placed in such a teacher's care is an abdication of the positive duty allocated the teacher by his employer. So too, a priest is expected in the course of his priestly duties to see members of the public, including vulnerable members of the public, on their own in his home. The abuse of a vulnerable boy by a priest in those circumstances is the abnegation of the responsibilities allocated to him. Nothing on the evidence suggests that it was ever contemplated by anyone at Manchester City that children would stay with Bennell, far less that he was required to accommodate them in the course of his ordinary duties. Adopting the language of Lord Millett and that of Stuart Smith, LJ, at DSN, there is nothing to suggest that Manchester City had either assumed responsibility for the boys staying with Bennell, or that it entrusted them to his care, and that the abuse of the children was the abnegation of any positive duty allocated to him by Manchester City. The fact that the child and the parents had been groomed into believing that it was in some way part of his role as a scout to have boys to stay with him at his home does not mean that that was the case. So that we submit that's quite a helpful way, showing that the judge is correctly applying the case, because one looks at what did Manchester City assign to him, whatever expectations the children's parents might have had, or however bewildered the children might have been, and therefore it was not appropriate to find vicarious liability. And much was made of what Lord Millett said in Lister, but of course employment, I remind the court, was not an issue in Lister, so all his observations were concerned with stage 2 of the test. And we do very much endorse what was put to learned friend in argument in relation to increasing the risk and how it's relevant, by looking at the Barclays case, where it could be said that by sending young girls to see a general practitioner who was going to do whatever he thought was appropriate to assess their fitness for work, that was in some way increasing the risk because he was seeing them alone. But that didn't change the fundamental basis of the relationship, which was not one of employment, rather it was one of an independent contractor. So if there was a risk, it certainly didn't play any part in the analysis, nor we submit should it have done.
Just in case you can help us, on the Manchester City Football Club, that's a first instance decision relatively recently.
Yes.
Do you happen to know, is it on appeal or?
Yeah, it's an application for permission pending.
Thank you very much.
Yes, and who knows? But we say that in a sense, whether it's rightly decided or not, although we would submit it is rightly decided, it shows how the test is now working, which is, in our submission, much more satisfactory than the law was hitherto. My Lords, I think those are essentially my submissions on the issue before the court on stage 1 and stage 2. But I now come to the ticklish question of the proper defendant. We sent by electronically a note to the court, but we do have physical copies as well.
Yes,
Yes.
Myself, I
Is it in
received
the bundle?
it just before we started.
It's in the bundle. Yeah.
And I'm not sure that it is.
We would encourage.
It was added to the bundle at 10:45 today.
Yes. We can. If it's easy, I can hand up. We've got copies for everybody.
It sounds as if we've got it.
It's the last document on the list.
Yeah.
Thank you.
Do we have the power of attorney, which is referred to in that letter from Watchtower, Britain? I think it is. Yes. Please find attached the power of attorney through which Pennsylvania operated in Britain at the material time. I find a.
Lord, I don't think we do.
About what it says, I'm afraid.
No.
It must be in the correspondence bundle, the party's correspondence bundle, because it was attached to this letter.
Yes. It says, please find the attached power of attorney through which the Pennsylvania.
At the moment, I'm not sure whether it's London operating under power of attorney on behalf of Pennsylvania, or Pennsylvania, which I think is probably more likely, operating under a power of attorney on behalf of London. But that couldn't be more different, and for my part, it would help me to know which is which.
Yes.
Well, you would expect it to be the former, I would have thought, because Pennsylvania isn't in the United Kingdom.
So I think
anyway, it would help to see it.
I'll see if I can provide that. Can I just take the court through the note, and perhaps there'll be any other questions that arose which I can try and assist the court with. At the time of the tort, Barry Congregation existed as an unincorporated association, but in terms of the title to the place of worship, the Kingdom Hall, it was held in trust by 2 or 3 adherents, so we understand. It wasn't until 1997 that the Barry Congregation registered as a congregation charity to deal with finances and property of the congregation. So before that, they were simply an unincorporated association.
The registration as a charity is merely relevant to its regulation. It doesn't alter its legal status as a body.
It doesn't. The Constitution did not set out the ecclesiastical rules and procedures, including matters such as the process of becoming one, or the appointment of deletion of elders and ministerial servants. And at the time, 1997, when it was registered as a charity, the trustees of the Barry Congregation were most, if not all, of the congregational elders. Mr. Schofield's witness statement explained the process for appointment or deletion of elders coming from the Bible. The Jehovah's Witnesses don't have infant baptism, so even if you've been baptized, say, in the Church of England, you'd have to be rebaptized if you were going to become a witness. And he went on to explain the exceptional disfellowship by a congregation, an ecclesiastical judicial committee, usually comprising 3 elders of the congregation, but only if the adherent was considered unrepentant. As to appointing elders, at the relevant time, the elders were recommended for the appointment by the congregation body of elders in consultation with the circuit overseer when he made one of his biannual visits to the congregation. So it looks like the appointment, as it were, came from initially from the congregation who decided that somebody was appropriate, consulted with the circuit overseer. If the circuit overseer agreed with what the elders said, he would complete what is called an S2 form with the elders and then submit it to the service department of the Ecclesiastical British Branch Office for approval, and the department would then either approve or refuse the appointment. And as to the deletion, explained a similar form were deleted. Yes, it was the S2 form again. That would be a form which the elders would send to the Britain branch office. Is that right? The circuit overseer would send it to the branch office in the case of ST. So accordingly, at the relevant time, it was the ecclesiastical British branch office that appointed or deleted congregation elders. He then described this.
Before you go on, that looks like the guarantee company in the small print at the bottom of their letter.
Sorry. Yeah. I'm not sure that's quite right. My learned junior is a considerable expert in this area. He's acted for them all over the world in different contexts. He probably has a better understanding than I do, and I may be, although it probably will make him uneasy, but I may ask him just to follow on that particular point rather than to give an answer which may not be entirely correct. Mr. Schofield also described the ecclesiastical structure, and then we set out what it is. There are around 90 branches of Jehovah's Witnesses established worldwide, and the activity of each branch office is overseen by a branch committee. The British branch committee has offices in London. They oversee the activity of the branch office and provide organisational support for the preaching activity. Congregation of Jehovah's Witnesses within each branch's territory are divided into circuits, and each circuit has approximately 20 congregations and a circuit overseer. So that's the overall structure. The order that the judge made, and there's no doubt that it's quite clear that the message was sent to the claimant that any judgment will be satisfied. So there's no issue about that, but I do understand that the court, in coming to a conclusion about the nature of vicarious liability, and in particular employment, would like to be as clear as possible as to the status of whoever either employed or quasi-employed someone. And it's proving a little bit difficult to track down, and it's explicable by the fact that since there was no longer going to be an issue, perhaps not enough time was spent on it. In fact, the judgment, which we get at 1, 2, 3, was against the first defendant, against the second defendant, which the trustees of the Barry congregation. And what the judge said was on the understanding that the first defendant undertook to satisfy any judgment against the second defendants. And then the Court of Appeals comment on this is at the beginning of Nicola Davis LJ's judgment, page 88 of the key documents bundle, where she says that the judge found that the first and second defendants were vicariously liable. Well, yes. 2, the first defendant is the worldwide governing body of the Jehovah's Witnesses. It was unnecessary for the judge to consider the relationship between the first and second defendants, as the first defendant accepted it would satisfy any judgment against the second. The appeal is brought by the second defendant. So that, as it were, is all there is in terms of the judge's assessment of the relationship. Of course, I think my learned friends already referred you to paragraph 1 of Mr. Justice Chamberlain's judgment at page 138, where he said that the trustees of the congregation are the second defendants to the claim. The first defendant is the worldwide governing body, has its offices in New York State. It's not necessary to consider. And he once again made the point that because of the acceptance of responsibility, there was no need to differentiate them when talking about defendants. Our submission is that the reality is, whatever the precise legal position, is that the congregation selected, prima facie at the very least, those who were to lead them, and those who were going to be ministerial servants and elders. So it came, as it were, from them. Yes, there was a process whereby a veto, as my Lord Stevens put it in the course of the hearing yesterday, and you've seen in the document we've handed in what happens and who is, as it were, responsible. But the reality is that the congregation appointed or responsible initially. If they hadn't suggested somebody, put it that way, if they hadn't suggested someone, it's unlikely they would have become an elder or a ministerial servant. And we do raise the question, would it make any difference if someone was a ministerial servant or an elder in terms of their responsibility? They're all expected to behave in a Christian way and to follow the doctrines which being a witness involves. But this is not like an appointment of a parish priest or an appointment of someone, of a rabbi or an imam or whatever it might be. There is no hierarchy in that sense, no garbs or anything of that sort. So really this is, although there is a worldwide organisation, this is something by way of an unincorporated association. In other contexts, unincorporated associations are usually sued by the chairman, treasurer, secretary as representative capacity. If there is no insurance, then all members of the relevant unincorporated association may be looked to for compensation against, for any judgment against the unincorporated association, and that may be the reality. Yeah, that won't arise were the courts to find against my clients because of the fact that the worldwide body will stand behind them, so the individual members of the congregation are not at risk. But in a sense, stripping away the legalities, the reality is this is the congregation appointing its own to lead, subject to the approval of a higher a safety check, as it were, from the higher branch office. Is there anything else that's wrong? Yes. I think there's one additional point that Leonard Jr. would like to add.
I hope I won't add more confusion than I need to. But just to clarify, my lords, as far as Watchtower Bible and Tract Society of Britain, which this letter, the 2016 letter, is on, Watchtower Bible and Tract Society of Britain was formed or created as a company in 1999. Prior to 1999, the legal entity was Watchtower Bible and Tract Society of Pennsylvania. And the power of attorney that was referred to in the communication, it is dated, it was indeed the communication between the parties dated July 31st, 1978. And it was a power...
1978?
1978.
But I thought you said that the British body was only formed in 1999.
It was.
Being party to a power of attorney in 1978.
So maybe I'll just clarify two things. So the Watchtower Bible and Tract Society of Britain is not the ecclesiastical branch office. They're two different things. The Watchtower Bible and Tract Society of Britain is essentially a title holding company for religious properties. It did have a role, and I'll get to that in just a moment, as far as its role after 1999 for a short period of time, as far as communicating religious guidance. Prior to that, though, the legal entity that was used by Jehovah's Witnesses in Britain was Watchtower Bible and Tract Society of Pennsylvania. And in the power of attorney, the power of attorney gives attorney to a Mr. William Googe, who was a member of the Ecclesiastical Branch Committee, of Britain Branch Committee. And in paragraph 2, of his powers, it included the power, and I'm reading the middle of the paragraph, to appoint ministers, agents, and servants in any congregation of Jehovah's Witnesses with full power to perform all the rites and ceremonies of religion of Jehovah's Witnesses. And I'm informed the way it would work, as indeed is put out in the witness statement of Mr. Schofield, is that the service department of the Ecclesiastical Britain Branch Committee would make the appointment of elders and ministerial servants, and continues to be as a matter of ecclesiastical practice. It would be communicated on the letterhead of Watchtower, Pennsylvania, up until 1999. And then, starting from 1999, Watchtower, Pennsylvania was no longer registered as a company, and it was replaced by Watchtower Bible and Tract Society of Britain, which for a few years afterwards continued to communicate, was used as a letterhead effectively of the Britain branch office, and that's no longer the case.
The Pennsylvania, the Watchtower Bible and Tract Society of Pennsylvania, was that an unincorporated association, or what?
No, it's a company. It's registered in Pennsylvania in the United States. So it wasn't the ecclesiastical body per se, but it has been used for publishing activities of Jehovah's Witnesses worldwide.
And so the power to appoint was given to William Googe, but the appointments were actually made by the Service Department.
Yes, so Mr. Googe was a member of the Ecclesiastical Branch Committee at the time, and the Branch Committee oversees the ecclesiastical activity, including the Service Department, the whole branch office.
So he acted under power from UKCO or Britain Co.
Well, Mr. Googe, and as from an ecclesiastical perspective, the position of the church would be they actually come from the Bible, but as far as the power of attorney...
No, I'm talking about the power of attorney here for the moment.
Power of attorney...
He has to contemplate him making appointments.
Yes, indeed, it does. And that power of attorney is from Pennsylvania Company until 1999.
Pennsylvania to Googe in Britain?
Yes.
Yes. And is Mr. Googe still...
No, he's passed away.
So, well, with his passing, the power of attorney disappears, presumably.
Correct.
So, what was the situation at the relevant time?
If I could just turn my back to...
Well, I wonder if it might be better, I politely suggest that to have a note in writing of what the appellant's position is on this, rather than trying to answer ad hoc.
Yeah.
Yeah.
Thank you.
Well, yes. My Lords, I'm grateful, Dan. I'm also grateful to my learned friend. I'm sorry to have sprung that on him, but we will endeavour to get done. And we're grateful for the questions, because I think we will endeavour to give as full an answer as we can to the various points that have arisen. And we'll do that in short order and send it, of course, to our opponents and to the court. And I'm sorry this has taken up more time than perhaps was envisaged, but there it is. I'm glad to say, however, that subject, of course, to any questions that your lordships have, those are our submissions.
Thank you very much, Lord Fawkes. We don't have any questions for you. We've run out of questions. Well, we're very grateful to all counsel for their assistance. As counsel will appreciate, this case raises legal issues of some general importance. We'll take time to consider what's been said and let you have our decision as soon as we can.